Download our complimentary guidebooks, checklists, and other useful financial resources at savantwealth.com/guides.
And welcome everyone to today's Savant Live webinar. Thank you so much for joining us. Today we're going to be discussing how to settle your parents' estate. My name is Alaina Davalos and I'm a wealth transfer advisor here at Savant Wealth Management. And joining me is going to be Mike Cyrs, our Director of Wealth Transfer. Welcome, Mike.
Thank you, Alaina. It's great to be here and welcome everybody.
So I know that this is going to be a hard topic for a lot of people to discuss. So the agenda today will be pretty broad, focusing first on those immediate steps to take after a loss. We'll then be discussing understanding the will and other legal documents, as well as financial and property management during the probate process. And lastly, we'll conclude with long-term planning and how to move forward. Mike, can you get us started here?
Sure, sounds great. We're going to start out again with the immediate steps. And I think there's a lot we can talk about in this program. There are a lot of things that need to be done, and we could certainly focus a great deal of time and energy on any one of them. But I think the important, hallmark thing to say is in the immediate steps, many people tend to think, boy, there are all these financial, tax, and legal matters that need to be addressed when something happens to a loved one, and I need to get started on those things. There's a lot of concepts floating around. There's a lot of uncertainty that's in the air, and of course, there's all this emotion going on as well. And I found in practice that people think I've got to get something done. There must be something that needs to be done with bill payment, settling it, taking control of accounts, the ability to make payment for bills and things like that. And I can tell you there's almost nothing that needs to be done from a financial or tax perspective right away. The code and all elements are designed to take your time. So for example, estate tax returns, federal estate tax returns are due 9 months after the date of death. The income tax returns are due at the end of the calendar year, and then you have until April 15th. Bills are going to get paid later on. Oftentimes the bills aren't even in yet. So there's just going to be a kind of a period of time where you're going to be able to stop and catch your breath. Now, this is an important time to go through this grieving process. So understanding that financial and tax matters can be handled later on, take time, gather the family, make sure you go through the process for grief and bereavement. And this is a time to work on memorial service, burial, to handle, who should be notified, et cetera, and to go through that process and understand that, again, there's going to be time for the other matters. So there are these different stages, shock, denial, that practitioners talk about. Understand that, you need to reach out, choose somebody to connect with them and communicate with them. Oftentimes, if there's a funeral home involved, there'll be a bereavement coordinator that you can reach out to and get in touch with, and different resources. There's griefshare.org. That's an organization that you can reach out to. The Haven Network is another one. And of course, there's some federal organizations and agencies as well, substance abuse and mental health services as well. So just take some time, catch your breath a little bit, and start to work through some things. Now, from a notifying relevant parties perspective, a couple of things to remember. Once you start working through things, there's this concept of disposition of remains. And a lot of people get nervous. They say, well, who's going to take control of that? There can be a point of conflict and concern with that. And there's a hierarchy in the law that says who's responsible for the disposition of remains. So it's similar if you don't have a power of attorney for healthcare. There's an act which says which family members, and this can be an area that there can be some conflict. People can disagree, family members, et cetera. There's a statute and a hierarchy that says, look to a spouse first if nobody's been given authority and control over that. If there's no spouse, then it's the children. If there's more than one child, it's the children by majority vote. And so this next concept is sort of once you've got through the bereavement and the grief process, and you're working through that disposition of remains, who's going to take control of that? Now, most states will have a law that allows you to create a document. It's kind of like a limited power, a mini power of attorney that says this is the person that's going to make those decisions. And much like a power of attorney for healthcare, you can name multiple people in succession to have that authority. And again, from experience, I think this can be a place where, again, if family members disagree, and people, are more transient. They might be living in one state, and then in another state, they might say, boy, where should the burial take place, which state, and what have you. And there can be some disagreement by virtue of cremation or burial and some of the arrangements. So designating a person under, not relying on the statute, but under this specific limited power of attorney that you sign that says this shall be my decision maker, it can relieve a lot of that conflict and really be a good idea. Now, all authority under powers of attorney for property and healthcare, these are the documents where you name someone to make decisions for you if you cannot make decisions for yourself. That authority terminates at death. It doesn't extend beyond death. So if you think you can take action, for example, under the for financial accounts under a power of attorney, you cannot. That authority is extinguished. The one exception to that is under the power of attorney for healthcare. In many states, you can add specific additional powers and include the disposition of remains within that power of attorney for healthcare. And some states, like Illinois, it's actually provided for within the document. So you might check your power of attorney for healthcare, see if you have that authority, designated to somebody to take care of disposition of remains. If not, then you might see if you have a Disposition of Remains Act in your governing jurisdiction, and create that limited power of attorney so that you can take some certainty over that situation. Funeral arrangements themselves. So now we've gotten through sort of the disposition of remains and sort of the argument, some of the conflict that can occur at that point in time. Who's in charge? Naming somebody, take control of that. I've always been a big advocate of pre-arranging funeral and burial arrangements or memorial arrangements. Okay. Now there are two concepts here to be aware of. There's prepaying and there's pre-arranging, and they're not the same thing. So you can make arrangements with a funeral home ahead of time, during lifetime when you're doing your estate plan. I think this is a super good idea. Go through the process, meet with them, check the box for the type of vault or for the type of casket or a service or memorial. They're happy to go through that process and create a file folder for you of decisions that are made ahead of time. The more decisions you make ahead of time, the easier it is. Of course, it's going to be in a postmortem context. And so pre-arranging, it doesn't cost anything. They're happy to have that record. You can keep it with your other estate planning documents, put it in a safe place, let people know where it's at, and the decisions are made ahead of time. So it's really going to be a gift to your family, and it doesn't have to cost you anything. The funeral homes are happy to do that because they know they're going to get the business later on, so to speak. They're the keeper, the custodian of that information. The other way is to prepay, and of course that can make sense as well. There are two types of prepaying arrangements. There are guaranteed and non-guaranteed arrangements. So the guaranteed arrangements, no matter what, you pick out your different elements for memorial service, funeral, burial, etc. And no matter the cost increase or the inflation adjustment, you're covered. It's guaranteed. The contract is going to cover that cost. In a non-guaranteed context, the dollar amount is set usually through a fixed premium of some sort or payment. This could be to the funeral home itself or to a third-party contractor, and any additional costs are not covered. Okay, so in that context, or in the context where you're not prepaying whatsoever, you got to think about how are we going to get those items paid for. And one of the best strategies that I would have in this regard, or suggestions, is a liquid account, a joint tenancy account. We're going to talk about this a little bit later, but in a joint account, a joint bank account, both parties will have access to the account during lifetime, and then immediately at death, the survivor can access those accounts as well. So if you have a joint tenancy account with some amount in there for funeral or burial or memorial expenses, it creates a continuing and simple and instant thread to cover those expenses, either in cases where items you've gone through the process of only pre-arranging, or in the context where you prepaid, but you've not got a guaranteed arrangement there. So funeral costs continue to rise, and burial expenses. The statistics are now from the National Funeral Home Directors Associations, the average cost is over $10,000. About 2/3 of individuals are choosing cremation now over a burial because of those costs. And it's definitely something that if you do ahead of time and kind of think through, I think there's some advantages here. Now, the one thing I also would like to point out, and it gets into the earlier discussion as well regarding bereavement, having that relationship, I think, ahead of time. Many of those funeral homes are going to have a bereavement coordinator, and that person is going to help too in that process, that grief process. They're going to be there, not only in those first few weeks, but usually with, some checkups later on, some wellness checks and things like that, even several months down the line. They're trained, they're certified and coordinated, and I think it can also have a huge advantage. I was looking at some statistics for the program, and it's amazing. 87% of funeral homes are family owned. And I think in this day and age, that says a lot, because again, if you give them that information and you get them involved and you've documented everything ahead of time, boy, that's gonna, now you've got a contact person. They're family owned. They tend to be small, either groups within a community, et cetera, close knit, and they're just really going to help you in this process. So I really encourage you to think about that. Okay, important documents to gather there, as it indicates: birth and death certificates, marriage certificates, military records, etc., deeds. The more information you can gather ahead of time and assemble and centralize, the easier it's going to be. And if this is an event that's happened, if you want to get down to taking action and getting some things done, these are the types of records that you're going to need. I would note that, for example, from the health department or your public records or vital records department, it can be very restrictive as to who has access to birth certificates, certified birth certificates, or marriage certificates, information that you might need later on to prove heirship, or to, for a claims process on a life insurance policy or a contract of some nature, annuity contract. So getting those things ahead of time, again, is a very good idea, because you're going to have the authority to do that as the owner, or the principal party of that record. You're not going to have to rely on other family members who are going to have to prove that relationship to obtain those documents. And again, some vital records agencies there might even be a problem with that. Like you don't have the right to this information, or you have to prove your right to this information before they'll get you a certified copy of those records. So creating that resource ahead of time, just always a good idea. And noting, of course, if you're in the military, there's you're entitled to, a flag, and there's a whole process. The form for that, the VA form, is 27-2008, and there's you can have that memorial flag. There's information on that form, again, 27-2008. You can get that from the post office or the local VA. And if you were in the military, certainly family members might want to know. You might put that information or that form in your sort of your record file for what needs to be done. Some people might consider writing an obituary. Again, it just, it's easier if it's done. It's out of the way for family members, and again, you're not sort of struggling at that point of time in those immediate steps afterwards. So at the bottom of the screen here, you'll see location, 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 and I can tell you it's super important. Put things in a place where people can access them. I've seen individuals use safe deposit boxes, and then the bank is closed on the weekend, or like this coming weekend, it's a holiday weekend and the bank is closed. I tend to recommend a safe at home. Family members don't necessarily need to know what's all in it or what to do. They just need to know this is where I go, and then they have access to it. Unlike valuables, which could be kept in another safe, or perhaps in a safe deposit box, this one might be fireproof. You might even keep it unlocked, so that if there is a break-in, they're going to see that it's just records and information. They're not really interested, nothing of value, and move on. But you'll still have a convenient place to access, to centralize all of that information, and to pull it together to make it easier on your loved ones later on. So continuing on, we came up with something to help you in this regard. We're going to send you this special Navigating the Loss of a Parent checklist in an email. You'll have that, and then we've also got another tool, so you can put this in in that repository. It's going to tell you what information and sort of the steps to follow. But we also have another document. It's called the Trust and Estate Administrator's Guide. And this is proprietary to Savant. It's about a 14-page questionnaire. It can be filled out, and it will draw out all kinds of information. Maybe it's a pet, and people need to know what who the veterinarian is and things like this. It's everything that could be useful and needed to make this process simple. And I can tell you, having been a practicing attorney, for about 21 years in private practice, the first call that I would get, people say, "What do I do?" And the answer is, well, the lawyer needs to see what are all the assets, what are all the information, can you pull everything together? Then I can tell you what steps need to be taken and what needs to be done. I can start to sort through things. And so these tools are super important, because if you can organize them ahead of time, location, put them in a place where your family knows where they're at, it's really going to streamline the process going forward. So those are some of the first steps to the immediate process. Let's talk about, Alaina, personal property items and the house. Everybody's got all these personal items. People tend to start going through a house or a condo or an apartment, and those are two of the big things that often come up is the personal property and the house. And then we'll talk a little about estate tax as well.
So similar to you, Mike, when I was in private practice working as a probate attorney, I had so many clients that would come to me and say, "What do we do about the house and my parents' personal effects? No one's living there. Is it safe? Who's going to pay the bills? Can I get reimbursed? Please tell me, how does this work?" And these are legitimate concerns, because there is a period of time between when someone passes away and when the estate is settled. So who's going to be responsible? And that is normally going to be the executor of the estate or the successor trustee of a trust that owns the real estate. So they're generally the only people with the legal authority to access the home, to remove personal property from the home, or to authorize an appraisal. They do also have the obligation to pay the bills and make sure that the property doesn't fall into disrepair before it's transferred to its eventual owners. Some things that we recommend to make this as easy as possible would be to change the locks as soon as you can, or to recode the security system. Make sure you know who is accessing the property. Also, keep paying the utilities. Whether the house is going to be transferred or whether it's going to be sold, the executor or the trustee can get reimbursed from the estate for these expenses if they're paid personally. And the last thing that you would want would be for the home to be damaged because the AC was cut off in the middle of summer in Atlanta, or the gas bill went unpaid in the middle of winter in Rockford. And not paying those utilities can damage the property. So do keep that in mind. Another recommendation that we make is to have the mail forwarded to the executor's primary residence, especially if the executor is out of state. This can help not only to keep track of the utilities, but it can also give you more information about the decedent's estate, especially when that person did not do as much planning as Mike just discussed. You could get a bank statement for an account that no one knew about. You could get a tax bill for a piece of property that's out of state and needs to go through probate. There's a lot of information that can be gained in the mail. So make sure, if you are acting as the executor, that you access that information. The other thing it's going to be a big theme of this conversation is having open and honest communication between everyone that's involved in an estate. That's the executor, the trustee, the beneficiaries, family members, whoever that is. While the executor is administering the estate, or even before they've been appointed, a lot of tension can arise between family members about what should be done and how things should be handled. What mom and dad wanted. That sentence comes up more often than you would believe. And I've seen more in-family fighting, both in my own family and with clients, over stuff than I ever thought would be possible. Siblings, whether they are 1 and 3, like my children, or 61 and 63, love to fight about things. And this fighting can ruin relationships. The best recommendation that we have to avoid this sort of scenario is to have open and honest communication with all parties. It would be ideal to have these chats with your parents while they're still living, but that doesn't always happen. So if you are the executor of your parents' estate or just a beneficiary, try to have those open and honest conversations respectfully and with transparency, especially if you know that you don't get along with one of your siblings, or if there's a high likelihood of fighting once your parents are gone. Encourage your parents to have those conversations now so that everyone is on the same page. Remember too that after a loss, this is a very emotionally driven time. And the last thing that your parents would want would be for y'all to be fighting over their stuff. So encourage them if you can and if you feel comfortable to have regular family meetings and explain why they made the decisions that they did. If this doesn't happen and you are the executor of your parents' estate or even an interested party, you have more to worry about because of different duties. You know, if you're the executor, you could be sued by your siblings or other beneficiaries of the estate for breaching your fiduciary duty. To try to avoid that, make sure you keep records of everything you're doing, especially financially. Try to avoid self-dealing if possible, meaning don't sell or distribute assets to yourself that may be perceived as unfair to your siblings. And then just generally try to be the leader of your new family, the one that just lost their matriarch or patriarch. And keep in mind that everyone is hurting. So let's flip the script to something a little happier, understanding the will and the other legal documents. Take it away, Mike.
All right, sounds great, Alaina. Great advice. Okay, so let's dig into the estate planning documents a little bit. Let's start the beginning of all estate plans with those powers of attorney for property and healthcare. These, again, as I said, are going to terminate at death. The authority ends. It's an agency. While I'm living, grant authority to this other person to make decisions for me if I can't make decisions for myself. If you're not alive, that agency terminates. There could be no agency. The contract ends at that point in time. The one thing I note here, and this is a recommendation we tend to have, is to include information regarding digital assets or digital asset authority. Anything you can do to write down usernames, passwords, store that information somewhere so that it's easily accessible. That's going to be a great idea, because although those accounts can get closed down, somebody can access that, be given to an executor or a trustee. And then remember that the powers of attorney for healthcare can give that continuing authority to dispose of remains. That's the one thread of authority that can continue on. So a little bit on powers of attorney. Let's proceed then to a will or to a trust. So get a lot of questions regarding wills or trusts. Wills and trusts, you know, the way I describe it, that they're really very similar in a couple of respects. Both will name someone to make decisions and to collect the assets, to pay the bills, and then distribute those assets. So there's going to be a person who's responsible for doing that. In the context of a will, they're called an executor. In the context of a trust, they're called a trustee. The difference is, so they're both legal documents. They have different formalities for execution. They both play that role. The big difference is, think about it this way. Under a will, the authority to do that comes from the court. It's derived by the court approving the will, approving the executor or administrator, and following them and monitoring them through the process. Where with a trust, it's like, I trust my family. I don't need court involvement. It's like a cell phone that's already charged. It's already empowered, and you're off and running. As I'll explain in just a little bit, probate takes time. There are a lot of steps involved, and it involves the courts. So it's going to be a little bit of a slower process. If you have a trust, I've had trusts administered within literally 10 days of the time of death. I mean, everything, the authority is there. You sign an acceptance of office as the successor trustee, which says, yep, I'm going to take care of these affairs, and you can prove that to whomever is a custodian of that account, and you're off and running. So wills and trusts. Now, when you have a trust, the lawyer, and don't get confused by this, they're still going to have you execute a will. And the idea is that for assets that aren't owned by the trust or payable to the trust, the will pick those assets up and put them in the trust. So you're still going to have sort of this will that's a safety net. Hopefully you'll never need it, but don't be confused by that. Those types of estate plans that use trust as the primary document or instrument of disposition, they're still going to have that last will and testament as well with them. So when it comes to these documents, another important element here, keep those in a safe place so that they can surface, the family can get at them. The fiduciaries, whether they're an executor or a trustee, they're gonna know what to do. Wills are also always going to get filed with the courthouse, even when not probated. So this is a requirement under state law, usually within the first 60 days of the date of death, to sort of flush out and get all of the wills at one place so the court can decide which one of these is the last will and testament. And if one of them was executed under duress or undue influence, that the courts can sort through that. So filing a will is different than probating will. Filing the will is always required. It doesn't cost anything. The original will is the only one that can get filed at the courthouse. That needs to be done, usually, depending on the state, within 60 days of the date of death. As I said earlier, don't worry about the legal and financial implications. If you don't get it done in 60 days, I've seen wills get filed a year later or 2 years later. There's no penalty, there's no requirements. Just try to find that document and get it over to the courthouse as soon as you can. Hopefully, again, it's something that can be done, inside a short period of time there. So one of the things you might consider doing is, I think, when you get these documents surfaced, the will is public record. So if you are in possession of a decedent's will, you can, once it goes to the courthouse, people can get access to it. So if somebody wants a copy of it, I would be inclined to freely make copies and provide it to different, family members, et cetera. It's going to be public record anyway. That's the purpose of it. A trust instrument, on the other hand, is not public. And if you're in possession of a revocable or living trust at the time of administration, a lot of times people want the trust to keep things out of the courthouse and keep them confidential. You might perhaps create a redacted copy of the trust instrument. That's what it's called when we sort of block out everybody's interest except that one beneficiary. You can still see all the administrative provisions, the trustee powers, the execution page, so that it was validly notarized, the date, et cetera. But it's going to hide the information regarding other beneficiaries. That's called a redacted copy of a trust, and that's probably the if you're a successor trustee, that's the proper course of action there. So, all right, we're going to give you some basics here. So, switching gears a little bit, all property in the world at the time of death can be divided, no matter what state it's located in, and no matter what type of property it is, into one of these sort of three categories that we have here, separated by the lines. Starting from the left, the first type of property is joint tenancy property. Okay, oftentimes husbands and wives will have property as joint tenants or own it as joint tenants. A house is often joint tenancy owned, but it doesn't have to be a husband and wife. Any two individuals, Alaina and I, could have a piece of property as a joint tenant. And what happens with joint tenancy is, at the death of one joint tenant, by a legal principle called right of survivorship, that property automatically passes to the surviving joint tenant. No lawyers, doesn't matter what the court says. It's really just, prove death, switch the account over, and there's also this ongoing, ability for two joint tenants to have access during lifetime. So simple and easy. However, the problem is at the second, once we get to the second death, there is no joint tenant, another joint tenant, unless you add another joint tenant. So it's going to be in this middle category. It's ultimately going to transfer freely at the first death, but then be stuck in the second category, which is in a person's individual name without a named beneficiary. Okay, that's the property that gets frozen or locked up at death. And the only way to unlock it is to go through this process called probate, which is a court process where the will gets filed, not just filed, but filed for the purpose of probate. You pay a fee. you file a petition, an oath of office, a bond, an affidavit of heirship, and you're basically saying to the court, empower the executor with authority, letters of office, to take control of this property. Okay, so they're going to be doing two things functionally, the court. One, approving the document to make sure that it was validly executed, done under duress or undue influence, and making sure the executor or administrator, depending on the terminology of the estate, is the right person to administer that property and nobody objects. And then they're going to issue the letters of office. There'll be a claims period. You'll publish notice in a newspaper, usually once a week for 3 consecutive weeks or something like that, telling the world, hey, if there are any creditors out there, come forward. And then the executor or administrator has authority over those assets. They can pay the bills, take control of them, pay the bills, and then distribute those assets to the beneficiary. The minimum time period varies, but it oftentimes is a year or more. And the reason is the process starts upon petition to the court, which can take sometimes several weeks post-mortem. Then you've got to get in front of a court. Oftentimes you'll have to appear, make sure all the documents are together. Then you get the letters of office. Now you've got to publish notice in the newspaper. So you got to contact the newspaper, start that publication period. That can take time. And then that triggers this tolling of this time period. Then you have to get back to court, close the proceeding, and that takes more time. So you're usually looking at a year or more to kind of go through that process. There is a shortened process. You can use what's called a small estate affidavit, sometimes used, sometimes it's called the poor man's probate. If you have assets of only a certain threshold, not more than 50,000 or maybe 100,000, again, depending on your state law, you can use this 2 or 3 page affidavit with a certified copy of the will to actually get authority to transfer assets. So that's the middle category. Okay, moving to the right, the third category is property that's in a decedent's name, but it's not joint tenancy, but it has a named beneficiary. There's a beneficiary attached to it. So IRAs, life insurance, annuities tend to fit in this category. And these are like contracts. When I die, pay these assets to the named beneficiary. They're just one-term contracts. Again, much like the joint tenancy, present a death certificate, doesn't matter what the will says or a trust potentially, and you're off and running. So the middle category is the problem area. The two elements on the side can work very efficiently. But remember, amongst joint tenancy, oftentimes you're back in probate. So we need a solution that governs that situation, and that's where a revocable or living trust comes in. So next slide here. Now we've replaced that middle category. We've created the trust, followed the formalities. It names the successor trustee. It has all of the dispositive provisions in it for distribution. And we've actually retitled the assets to the trust. Or, for example, it might be life insurance and IRA. We might make it payable to the trust. And then what happens is, as I said, where we can administer things literally within days or a few weeks, you accept your office of successor trustee, you get a tax ID number from the IRS to manage the tax consequences, pay the bills, and you're off and running, and you can wrap things up in short order. Now, when it comes to what happens when someone passes away, a loved one, a parent or what have you, you're going to have to find all of the assets and then find which of these categories they're in, because that'll tell you what needs to be done. So, for example, if you're a trustee of the trust, that doesn't give you any authority over the IRA, which has named beneficiaries. It has its separate transfer mechanism. It is its own independent process, and the beneficiaries can actually get death certificates and complete the process for transfer on those assets, and not involve the trustee. If the trustee is the beneficiary, well, then they would have authority to get involved and to move those assets. Same thing, sometimes I think people get confused. Well, I'm the dad's executor or I'm mom's trustee. Again, that doesn't have any authority over joint tenancy property. Separate legal principle, separate transfer mechanism, and you have to stay in your lane here. So I think the advice that we have is just to remember, look at the assets, identify them, understand that the POAs are void at death, other than the disposition of remains possibility under the POA healthcare. The POAs are out. Now we're looking at these 3 buckets plus potentially the trust bucket, and we're working through, what do I need here, or where does my authority come from in the process. So hopefully those diagrams help you a little bit. Just, kind of a closure on understanding the probate process. I liken it to kind of like a car wash. If you don't have a trust instrument to get you right through that process, some clients like probate. Some attorneys even recommend probate so that they can cut off the claims of creditors and fix them by publishing that notice in a newspaper and saying no more creditors after this point in time. It's a process that works. It's been around forever. It's court monitored, and it will get the job done to get authority to take control of those assets that are in a decedent's individual name, no beneficiary, and make sure there's an accounting at the end to beneficiaries and to the court. The final accounting that it shows here in this process, the court is also going to want to know, is everything done? So some people design their estate plans to make sure that court involvement and court authority are there. So Alaina, anything to add, talking about just sort of revocable or living trusts and some of the resulting trusts that can come up underneath there?
Yeah, for sure. So, you touched briefly on that someone may set up a revocable living trust because it can pass assets easier, faster than having to go through the probate process. But similar to the will, the revocable trust can also help to provide further protection for those assets. They can be utilized to set aside the assets for the lifetime use of a surviving spouse and provide that at the death of the surviving spouse, the remaining trust assets shall pass to named descendants or other beneficiaries. So it can get really confusing if you've got a revocable trust-based plan that then creates subtrusts underneath it. Whether those subtrusts are for a surviving spouse, whether they're for descendants, that terminology is used and intermingled, and it can get confusing which trust is being talked about. But generally, the revocable living trust becomes irrevocable at the death of the grantor with respect to the grantor's property if it is a joint trust. For example, if a primary residence and a brokerage account were titled to the trust with trust terms that allow the surviving spouse the lifetime use of the residence and income from the brokerage account, then at the death of the surviving spouse, the remaining trust assets are split between named children. So that's a very popular plan for a second marriage to help provide for that surviving spouse, but then guarantee that your assets go on to your children. Another big benefit of the revocable living trust is, like Mike mentioned, because it doesn't have to go through probate, it doesn't become public record. And if that trust is fully funded during your lifetime, avoids that probate, if no one needs to see the will, shall we say. And that can be helpful if, for example, you're disinheriting someone. If, let's say, your parent is going to be providing for you and not your sibling. If they transfer assets via the will, then your sibling could have an opportunity to contest that will. And that's when things can become very expensive. Whenever there is a will contest, whenever there's any dispute about the legitimacy of the will, a revocable trust may not need to be provided to that disinherited sibling. And so it creates a lot easier path for assets to transfer without the likelihood of controversy. And again, just to summarize what Mike touched on, because there's so many little pieces when it comes to probate, when it comes to trust administration. Your parents deciding whether to have a will or a revocable trust is discussed during the estate planning process. They would have talked to their attorney about what works best for their own plan. And some of those talking points are that the will does have to go through probate, will add expense and delays. It becomes public knowledge, and some people are very cautious about what information they want their neighbors to know. With the revocable trust, property can be transferred immediately, as Mike discussed, and without court involvement. However, not everyone has the time, the mental capacity to take on that homework of moving their assets into a revocable trust. And so your parents would have talked to their attorney about all of these different aspects, all of this minutia of estate planning. Same goes to jointly held property. Is that a good idea? Should we have that bank account to pay for funeral expenses, or should we have a POD or TOD? A lot of details in those conversations. The other important part of probating an estate or administering a trust is going to be the estate tax conversation. So if you hear your executor or trustee talking about estate taxes, it's probably a good thing, because thankfully these taxes impact very few families today. There's actually a very high net worth threshold that has to be reached. Currently, it's $13.61 million per person. So a married couple has about $27 million of net worth before their estate will have to pay any federal estate taxes. I do wish every one of our clients an estate tax problem. There are, however, state estate taxes as well. Illinois, for example, has a $4 million state estate tax exemption. So a married couple may have to pay Illinois estate taxes, but not federal. Additionally, there are state inheritance taxes. So make sure that you're familiar with your state's laws on this topic to see if you personally would have any state inheritance tax liability. And the thing is that these tax rates, they vary. The federal rate is 40%. So anything above that $27 million would be subject to a 40% tax, whereas the state estate tax rates are usually much lower. Talking about those trusts, and I mentioned that sometimes sub-trusts are created. You may see that in your parents' documents or in your family members' documents. There seems to be a lot of stigma against trusts, that they're created for control from the grave. Well, they're also very oftentimes used for tax planning. So keep that in mind if you see those sub-trusts. It's not that your parents didn't trust each other. They may just have had some tax issues to consider. And Mike mentioned this also, just about beneficiary designations. You're going to see when someone passes away how many different places assets are coming from. And there is a lot of possibility for tension between family members. Because if the will says one thing, but the beneficiaries say another, the executor could easily be blamed for that. And without proper planning, there can be a lack of cohesion. So some assets that pass under the estate or trust, some assets pass automatically. It's important to understand those differences, because once someone is passed away, those beneficiaries, those things are set in stone. There's usually not a lot that can be done, and misunderstandings about what's going on can lead to conflict, usually between the executor and other beneficiaries of the estate. So some assets will pass via that joint ownership. If you're a joint owner on a bank account with your parent, you may have immediate access to that account at their death that your siblings or the executor of the estate does not have. Sometimes you'll see little letters listed on accounts, or usually on real estate deeds as well, because that's another commonly held joint property, and that's JTWRS, joint tenants with rights of survivorship. Sometimes there's an O in there too. And that usually means that the survivor of that joint asset inherits the property at the death of the first joint owner automatically, no probate needed. Sometimes that's good, sometimes that's bad. And so that's something that Mike and that we deal with here at Savant every day, are those beneficiary designations. Because you'll see these on retirement accounts and life insurance policies. Some states do allow designations to be put on LLC or other business interests, but that varies state by state. These assets usually transfer automatically to the named beneficiary once the death certificate has been provided to the account holder. So it's always important to look at who those beneficiaries are. I've got some information here about retirement assets because there are very particular rules about retirement assets. The surviving spouse has the right by federal law to be the beneficiary of the decedent's qualified plan's retirement assets. So IRAs, 401ks, unless the spouse waives that right in writing, they're usually going to be the named beneficiary. In second marriages, this can cause some confusion, so it's something to plan for. The surviving spouse can roll over the IRA, the Roth IRA, into their own account. And because of the tax deferral flexibility, retirement assets often name the surviving spouse as the outright primary beneficiary as opposed to in trust, with the moral understanding, the handshake deal, between the couple that the survivor will name certain people, the children usually, as the beneficiary upon the survivor's death. And there's one other little designation that you may see from time to time, which is a TOD or a POD. That stands for transfer on death or payable on death. These are most often seen on bank accounts or brokerage accounts. And again, they transfer the asset automatically to whoever is named as the TOD or POD. A lot of what we do here at Savant is making sure that all of these different designations align to make sure that they are cohesive with our clients' plans, because there's so many little pieces. And we want to make sure that the plan actually comes to fruition outside of the will or trust. So we're going to talk a little bit now, speaking of Savant, about financial and property management. So now that you've become a little bit more familiar with the legal jargon, let's talk about logistics, the managing of assets. Who is going to be responsible for managing the assets while an estate is open? And generally, that's going to be the executor or the successor trustee. They'll be responsible for notifying banks, financial institutions, other third parties of the decedent's death, accessing those bank accounts, paying bills, and managing any real estate, as well as taking care of and distributing personal belongings. They'll also be responsible for collecting any debt that's owed to the decedent, as well as paying any final bills, including filing the final income tax return. So pretty much they'll be in charge of the money. They'll also be responsible for collecting any debts, like I said, paying those bills. That includes dealing with any outstanding mortgage, paying any outstanding credit cards, any debts related to the death of the decedent, promissory notes, any place that that person owed money to. They'll also be responsible for filing the final tax returns. And Mike, can you tell us a little bit more about that?
Sure. So let's dive into the income tax side a little bit. Alaina alluded to the estate tax side, which because of the increases to the federal estate tax exemption, most of us are out of the estate tax side of things, and you're lucky if you're not. And then there are very few states that continue to have a state estate tax, but it is something to be familiar with. But the income tax side of things is different. Everyone is going to be subject to income tax. I describe it as a continuing thread, from life all the way through. And the U.S. Treasury and the state income tax departments of revenue, they don't give us any. There aren't any periods of time where they say, "Don't worry about it," until you get it into the hands of somebody else. We're not going to tax it. Nope, they want a piece of the bite of that thread all the way through. So up until the date of death, the tax attributes, dividends, interest, and income are going to be taxed on the decedent's 1040. If you're a surviving spouse, you'll simply survive. You'll file as a surviving spouse, picking that up, unless you get remarried between the point of death, of course, and the end of the year. So that's through the date of death. At the point of the date of death, we need a new taxpayer in there, and this is where either the state or the trust, or possibly both, are going to go out and get a tax employer identification number, an EIN. It can be done online. It's easy and instantaneously. You get your EIN because when you pass away, so does your Social Security number. So if you have an account that's registered to a trust and you're a successor trustee, you're going to get this EIN, and you're going to take the assets out of the Social Security number of the decedent. You're going to register under this new employer identification number, this EIN, and that's going to then start to trap on what's going to ultimately be a 1041, a new tax return going forward, until those assets, if they are distributed outright, in other words, they're not staying in one of these continuing trusts that Alaina has talked about. If they're going to go to the beneficiary, then at the point that the trust terminates and the assets go to the named beneficiary, they would be back on the 1040 of the individual beneficiary. So think 1040, 1041, and then 1040 again. Now you can combine an estate EIN. There's a tax election that you can make where the EINs can be combined into one EIN, and you can use a fiscal year rather than a calendar year. And there's some nuances in there, but basically we have to make sure we get this taxation all the way through. Those returns are going to be due, April 15th if it's a calendar year following the year, of death, and then you'll pick up on that 1040, 1041. When that income, there'll be deductions on the 1041, and then as those assets are paid to the beneficiary, they'll carry with it the income tax liability. So what happens is the 1041 usually gets zeroed out. There's usually no income tax there, because any tax that it has, it's pointing to the named beneficiaries and saying, we're going to pick that up under the 1040 of the individual beneficiary. Those assets went to the beneficiary. That's where the tax liability should be, and it gets zeroed out. So a couple of tips here. Oftentimes, when we figure out what's going on with a tax perspective and we want to work through this arrangement, we might upfront pay a tax preparer so the 1041 can be prepared, but knowing that the tax liability will be assessed back to the beneficiary, we're not keeping anything, hanging on to any residue to pay that tax liability, because we're just going to ship that off to the beneficiary. The payment of the return, however, you'll pay that up front so that return can get prepared, and that'll push you through. For example, as I said, if you're trying to wrap things up in a couple of weeks, you might prepay for preparation of the return, but then rely on the fact that the beneficiary is going to be saddled with the income tax on that. Couple of things. The income tax is only on the interest and dividends during that period from the time of date of death to the time of transfer. It's not a tax on what you're inheriting. It's not a tax, an income tax on the lump sum. That's income tax free. Okay, so the house or the CD itself, you're not going to be subject to income tax there. It's just that appreciation, that dividend and interest. The appreciation, what you want to do on the 1041 is when you move those assets, a taxable account, out of the name of the individual and their Social Security number, you get a basis adjustment up to fair market value. So if they have a low cost basis and they're highly appreciated and there's an inherent capital gain in there, you're going to adjust those assets to fair market value under the new EIN, so that when things are liquidated, there's no capital gain there. This is something that you're going to see in the news. They're talking about, maybe a loss of a step up in basis, or some possible only a credit for basis, because that's really, where, for example, the U.S. Treasury could raise a lot of revenue is not allowing these assets to step up. But remember, for now, step those assets up. Often then there'll be a liquidation event, because as a trustee, you don't want to be stuck having a decline in market value and have a fiduciary duty and the beneficiary saying, hey, what happened to my assets? They declined 15%, from the date of death to the time I received those assets. So often the course of action is get the EIN, step up the basis, liquidate, pay the bills, and then transfer the assets, knowing that you've washed out the capital gain. And then you don't have to worry about a capital gain or loss until the time for transfer to the ultimate beneficiary. So estate tax return, that's due 9 months after the date of death if you hit that threshold. So, but again, that's going to be fairly rare. Okay, so let's move on then to some long-term planning, our last topic. Just real quick, because we want to address a couple of questions as well. Estate settlement, if you're a trustee, it may be a good idea to provide that accounting and then to have the beneficiary sign off on it and say, yeah, I approve of that accounting, and I'm going to sign this release before the final transfer and disposition of all the assets. And the reason is that you're basically hedging against any losses. You're saying, look, do you agree with everything that I've done? Here's the assets I've collected. Here's the bills I've paid. Maybe there's a fee taken by the trustee for the time and the energy that was involved, and you want everybody to approve it, and then condition their final payment on that release. If they don't agree, that might be a reason to go to court and then say, hey, to the court, hey, court, I want you to certify and acknowledge that I've done everything correctly. Some individuals will keep a reserve, making sure that takes place. That's another another avenue or approach there. And then I've already talked about sort of prepaying that 1041 preparation so that you don't slow things down. Okay, reflecting and honoring, just a couple of notes, and then we'll see if we can get to some questions, Alaina.
Yeah. So just a reminder, after everything you guys have heard today, clearly this is a very complex part of life. And I hope that no one has to take these notes into consideration for a long time, but I hope that this does serve as a reminder to update your own estate planning documents. Make sure that your family is taken care of as well. And now we don't have time today to address everyone's questions, but if you would like to discuss your unique situation, please schedule a complimentary 15-minute call by clicking the link in the chat to schedule a time that works for you. These are our disclosures and then our questions.
Great, I can take a few. The question regarding changing the lot, and there are a lot of questions out there. This is just a topic. I think that there's there can be a lot of things to cover, and it's really too hard for us. But changing the locks, I've seen situations where people get into the house or the home. It's just a good idea. You don't know who has access to it. It could be gardeners. It could be any number of people. So oftentimes it's a good idea to secure the house, secure the personal property. And don't let people take personal property out, especially if you're a named executor or trustee, because you need to account for that. If people come into town, you can always take a picture. You might need an appraisal of it even. And it's just better to get control of things and secure things. Sometimes people will even watch obituaries in newspapers and they'll break into homes. So having a security system was something that my old law firm, we would frequently recommend just change and put in place a security system, because if somebody saw that somebody passed away, they might try to break into the house knowing that there's nobody there any longer. Certainly, trust can be named as a secondary beneficiary, a spouse primary, often the case. And then a trust secondary to receive those assets, and then make sure that the estate plan flows according to the contingencies within the trust. So that's often a good idea. You see any questions you like there, Alaina?
Yeah, there's one. Someone asked, what is the difference between an EIN and a TIN number? That one's really easy to answer. It's nothing. An EIN just stands for an entity identification number, and a TIN just stands for a tax identity number. But we will look through your questions and get back to y'all with responses. Like I said, if you have any questions, please reach out. We'd be glad to help.
Thanks, everybody. Have a great day.
Thank you.
If you enjoyed this webinar, visit savantwealth.com/guides and download our complimentary guidebooks, checklists, and other useful financial resources.